Well, good afternoon, everyone. I am Washington Gun Law President William Kirk. Thanks for joining us. I'll tell you how we decided to do this live thing, but this is going to be live updates on the Carmelo Anthony trial. They went to lunch break today. The defense is in its case right now. They went to lunch break today, and rumor floating around there now is that they have not been let back into the courtroom, except for Carmelo Anthony's family has been let back into the courtroom. People have seen the head prosecutor, whose gentleman, his name is Bill Whiskey. I've been doing a good job. Um, Go into a separate conference room. So I will tell you, having tried hundreds of cases to verdict myself, both as a prosecutor and a defense attorney, that this has one of two possibilities. Either number one, they are discussing a potential plea deal. And I'm going to go through the testimony that's been produced so far during this trial to understand why, so you can understand why the defense attorneys may actually be looking to cop a plea on this case at this point. The other thing they could be discussing, however, is whether or not Mr. Anthony himself will be testifying. Although, in most cases that I've tried, that's kind of a last minute thing. And surprise, surprise, we're testifying or we're not. So, again, every jurisdiction does things differently. The judge on this case is the Honorable John Roach. The chief prosecuting attorney on this case is a gentleman named Bill Whiskey. And the defense attorney is a gentleman named Mike Howard, very talented defense attorney. But I can assure you that a defense attorney is only as good as the evidence they are given. One of the things I will say about Judge Roach is he really knows how to step on the gas pedal. This case basically started taking testimony on Thursday. They worked through Saturday. The state rested late Saturday afternoon, about 2 o'clock Saturday afternoon. The state rested, and in that time, they had called 21 witnesses. 21 witnesses in like 2.5 days of testimony. We'll explain why some of it probably went quick, but a lot of testimony, and I've never heard of a prosecuting attorney being able to put on 21 witnesses in 2.5 days. I know I was never able to do that. Some of the big cases that I prosecuted a lot of times were child sex offenders, so you would have multiple counts and incidents that involved a number of months or years, and so you might have 30, 40, 50 witnesses to put all the counts together. That might take 2 to 3 weeks for the state's case in chief, so they are stepping on the gas down there. Okay. One of the things that we're going to try to promise all of you guys is going to try to be a little bit different than some of the other content creators out there that have been talking about this case. I mean, no disrespect to any of them. Everyone's got their own style, how they want to do things. For those of you who are familiar with Washington gun law, or if you're checking out Washington gun law for the first time, we do talk about Second Amendment self-defense issues on this channel all the time. But the most important thing we try to do is we try to keep it down the middle. Okay, because at the end of the day, there's enough content creators out there that are going to tell you how to think, how you would vote on this case if you were on the jury. We're not going to do that around here. You're all big boys, big girls. You can think for yourselves. We are going to give you all the stuff to think about, and we will give you explanations of things that happen in court. Some of them will be very thorough, accurate explanations. Others might be speculation, and I will let you know which is which. But again, I started trying cases in 1997. Spent 3 years as a prosecuting attorney in Seattle, Washington for the King County Prosecutor's Office. Tried a lot of cases, tried a lot of very serious cases, launched into my defense career in 2000. And as a defense attorney, have tried hundreds of cases to verdict. Got great stories about winning cases that I had no business winning. Trial attorneys that are honest with you, however, will also tell you about cases they lost that they had no business losing. I have a few of those as well. I do want to go over with you guys real quick what the law is, because at the end of the day, every trial is two sides are going to tell a story. There's a lot of professors out there that'll try to make trial work very scientific. It's not really scientific. It's storytelling. Okay. One side's going to tell a more plausible, believable story. That's the side that is likely going to prevail. And so at the end of the day, every trial is merely the jury's application of facts to laws. And does it fit or does it not fit? So I want you to understand that if this case were to be tried to conclusion, okay, the jury is going to be instructed the following. And this comes from Texas Penal Code, Section 9.32. A person is justified in using deadly force against another One, if the actor would be justified in using force against the other under Section 9.31, and two, and when and to the degree the actor reasonably believes deadly force is immediately necessary, A, to protect the actor against the other's use or attempted use of unlawful deadly force, or they can also use deadly force there, and B, when you have a whole bunch of crimes there. Now, in general, we only get to use force in defense of ourselves, others, or property, as long as the force we use is reasonable, necessary, and proportional. And so, one of the big problems that the Anthony defense team has in this case is that even if Mr. Anthony was lawfully permitted to use some force in defense of himself, he would have had to been encountered with having unlawful lethal force threatened against him, or having some type of very serious felony being committed upon his person before he could actually justify taking his use of force all the way to a deadly level. And candidly, as I go through the testimony here, the defense has not been able to produce any evidence that suggests that. And I'll be honest with you. Also, I have been tracking the defense witnesses, and they have been lackluster at best. Now, again, I'm not trying to tell you how I think this case is going to go, and I'm not being critical of the defense attorney in this case, because, candidly, again, you can't make chicken salad out of chicken shit. But let me explain to you what has happened. So this is how the trial has gone. We start on Thursday, day one, June 4th. The very first witness was Mark Porter. He is a forensic video analyst for Tarrant County. There was some video that was shown of the incident. They were grainy videos. They were taken from distances. It unfortunately didn't show a whole lot, didn't actually show the specifics of the attack. Although I will tell you that the specifics of the attack have not really been disputed that much as to what occurred. The witnesses' testimony have all been pretty consistent here. So while the video didn't show us a lot, it didn't really provide any type of exculpatory evidence for the defense either. One of the things that, and this is really tragic, this whole case is tragic. In 15 minutes and 20 seconds, Austin Metcalf entered the stadium, lost his life, and Carmelo Anthony was under arrest. This all happened in just a little over 15 minutes. It's terrible. It's terrible. And on cross-examination, again, the expert did testify that the video has limitations. Video does have limitations based upon the location of the camera, and where the camera is in relation to the incident. And so videos can be very, very helpful. Sometimes they can be very, very damaging, depending on what your theory of the case is. And oftentimes they really don't do a whole lot, depending on the quality of the video. That was the first witness. The second witness was Robert Starr, who was the Frisco High School track coach. Pretty powerful testimony here. He is the one that kind of said, hey, listen, the track culture is one where when the kids set up their tents, that is their territory. Everyone else stays out of that. He also testified, of course, that weapons are not allowed in Texas high schools. They're not allowed in any high school. Starr told the jury that he saw commotion by the tent and tried to make his way over. When asked what he found, he said, I could see Austin on the ground. His face was purple, and he had a big hole in his chest. And this obviously evoked a lot of emotions out of the family of the now deceased. And I can only imagine what they're going through and what a gut-wrenching process this in. Witness Starr began weeping while describing the moments following the stabbing. He said he made his way to Austin, where trainers were working on him. He told he heard Hunter say, do something, and point towards Anthony. Starr said he approached Anthony, who was with his coaches. He said he put his hand up and told Anthony he wasn't going anywhere, describing the moment as surreal. He said that Anthony was not hysterical or anything like that when he walked up. And then by the time he went back there, people were on their knees and they were praying. And as he put it, quote, I knew Austin was gone. It was a horrific injury. It was a horrific injury that Mr. Metcalf suffered. And unfortunately, it was a rather rapid death. So that is the second witness. The third witness was Tiffany Whitaker. She's an athletic trainer for one of the high schools. She tried to provide some first aid to Mr. Metcalf. She did testify that he regained a little bit of color, but that was false hope after she saw the wound. And what on cross, she did say that Mr. Anthony did not try to flee the scene or was not disruptive or combative when he was being detained and arrested. And we'll get to the nature of the injuries because the nature of the injuries were pretty bad. For those of you just tuning in, thank you very much. We are Washington Gun Law. We talk about this kind of stuff all the time. We try to keep it right down the middle. So we're just going to be talking about the facts that have been adduced at trial. I'm not going to tell you what they mean. You get to decide that. We'll also talk about the law because the law is written right there in black and white. For those of you who have just joined, and let me do a quick check here. Apparently, there is a delay in trial after the lunch break. The only people who were allowed back in the courtroom was Karmelo Anthony's family. That, as a trial lawyer, indicates to me that there may be discussions between the prosecution and the defense about a possible plea deal. Let's remember that Mr. Anthony is charged with murder. He is not charged with capital murder, which means the death penalty is not in play here. Never was put on the table in this case. He is looking at a sentence anywhere from 5 to 99 years if he pled to this charge. I will tell you that if I were the prosecutor right now, the only type of plea deal that I would probably be discussing is Mr. Anthony pleading to the charge as is, and then we could negotiate what the agreed upon sentence would be. I don't see this case being reduced down to a manslaughter or anything like that. Okay. The fourth witness to testify was Vincent Hooper, Heritage High School football coach. Hooper testified that he put his arm around Anthony's shoulder and told him and then this is right after the incident. And then Carmelo Anthony told him, he put his hands on me. I stabbed him. If that is what happened, while someone unlawfully putting their hands on you could be considered the use of unlawful force, and you might be able to use a little bit of force in defense of yourself, putting your hands on another person without more, just in any state, is not going to rise to the level of threat that would actually permit the use of lethal force. You also talked about how Mr. Anthony was very emotional after he confronted him. It's basically saying that if that young man dies, you've changed the rest of your life. Mr. Anthony kind of muggingly said he's not going to die. But then when Mr. Hooper asked him, well, what if he does? That's when Anthony broke down. All right. There's a gentleman named Joshua Redmond. He's an Army veteran and a Liberty High School coach. Also has a lot of CPR training and first aid training. He was one of the first to arrive at the scene and try to treat the wounds. His quote was, "I knew he was gone." That's how bad this wound was. A lot of physical evidence came in through this witness, a lot of photographs, bloody clothes, things such as that can be very impactful on jurors. And that was pretty much all of the testimony we heard on day one. On day two, June 5th, the prosecution started with Neil Adams of Frisco Fire Department. He was one of the first medics to arrive on the scene. He described that Mr. Metcalf's pupils were fixed and dilated. He was gray and he had no pulse. So unfortunately, by the time the first responders got there, it appears that it was too late to save Mr. Metcalf. When you understand the nature of the injuries, which we'll get to here in a few moments, you're going to understand why that was. The next person to be called to the stand was Frisco police officer Eduardo Cortez. This has already been reported, but this is a little bit of powerful evidence. He's the one who detained Mr. Metcalf, placed him in cuffs. He radioed in that the alleged suspect is detained in cuffs, at which point Mr. Anthony stated, I'm not alleged, I did it. His body-worn camera that captured all of that was admitted as an exhibit into evidence. And again, Mr. Anthony was heard on the video evidence saying, he put his hands on me. I told him not to, but he put his hands on me. Even if true, putting hands on another person could certainly get you knocked down, could certainly get you shoved, might even get you punched. But having a knife plunged through your chest is probably, in our opinion, a disproportional use of force. Ultimately, if this case goes to a jury, it's going to be for the jury to decide. On cross, and again, I was looking for where is the defense going with this? What is their theme? Sometimes you could see a theme weaved through cross-examination, certain areas that they stay out of, certain areas that they pound away on. Haven't really seen the theme. And again, I'm not being critical of defense attorney. I've done my homework on it. He's a very talented, very capable attorney. It's just sometimes you got to play with the cards you're dealt. And I don't know if he was dealt a good hand here. He got Mr. Cortez to agree that the possession of a knife under 5.5 inches is not illegal in the state of Texas, which is true. It's not. The problem is possession of a knife on school grounds in the state of Texas, which this was, is in fact illegal. All right. Frisco police officer Jacob Schultz was the next to testify. The knife was actually admitted into evidence through him, marked as an exhibit, and admitted into evidence as him with blood still on it. More body worn footage came in there. The next witness was Stephanie Martin, a Frisco Police Department criminalist, and she basically testified to trying to secure the scene and gathering evidence, taking photographs and stuff like that. Then we get into all of the students. We're not going to mention the students' names for a couple of reasons. Number one, the media is not supplying them, and that's fine because even if they did, you got to imagine what these 16, 17, 18-year-old kids are going through. They saw one of their friends get murdered. Now they're in court having to testify about it. It could be absolutely a horrific experience for all of them. I'm sure it is, and their families. And so we don't really necessarily need to be exposing their identities. Okay, first one, 17-year-old student was asked questions. Did anyone try to gang up, mob on him to get him out of the tent? This is the prosecutor asking about, like, was Anthony being surrounded by a bunch of people, threatened in any way? The answer was no, sir. And then the witness was very specific that Mr. Metcalf had placed his hands Mr. Metcalf had placed his hands on Mr. Anthony, but that it was a light shove and never knocked him down or anything like that. And then all the witnesses testified that the puncture wound occurred almost immediately thereafter. The next witness, this would have been the, I believe, sixth or seventh witness called by the state, 18-year-old student, was asked, do you think Karmelo Anthony acted in self-defense that day? No, sir, was the answer. Did Austin Metcalf want to fight that day? No, sir, was the answer. Did it appear that Austin wanted to fight? No. On cross, the witness testified that Austin grabbed Karmelo, which knocked his body back, but he said that as soon as Austin touched Karmelo, he was stabbed. So there's a little bit of dispute as to the nature of the shove, the strength of the shove, but even the worst versions of it, it is just a shove. And again, if unlawfully using force in that situation, Mr. Anthony would be allowed to use some force in defense. The problem is he going to rise to the level of lethal force? Okay. The next person to testify, 16-year-old. Can you imagine being 16-year-old and having to come in and do this? This would have been horrific. Was present for the incident. He described the push as a one-handed light shove to get out. On cross, he admitted that Austin was larger than Karmelo and that some could find him intimidating. Okay, so that kid was obviously a large kid. But again, the type of physical activity that's being reported here is a shove. All right, then a 17-year-old witness testified that Austin told Karmelo, I'm not going to fight you at a track meet during the incident. When describing the interaction between Austin and Karmelo, the witness said that Karmelo provoked Austin. Remember that word, provoke. The state drilled down into the witness' use of the word provoke, asking whether they understood its legal significance, because it does have legal significance. The witness says no, but that he thought it was the right word for what he saw. If provocation becomes one of the big theories, which it very well could be, and we'll talk about that in a moment, this witness's testimony could be very, very damaging to the Anthony defense. A former Liberty High School student was the next one to testify. I don't know how old they were. I don't care. She testified that Karmelo was the aggressor and that she believed a fight would happen. She said she did not think Austin wanted to fight and that Karmelo was trying to antagonize him. Again, we're going to talk about provocation. When she was asked about what she saw, she began to cry, wiping tears away from her cheeks. The witness told her that the witness was asked, did this interaction have anything to do with race? She said no. Did it have anything to do with Karmelo acting in self-defense? She said no. On cross-examination, this is sometimes cross doesn't go the way you want. She testified that Karmelo was the aggressor. That's not the kind of evidence you want to deduce out of cross-examination. So that's that witness. Okay. Another 17-year-old witness was asked, quote, do you think Karmelo acted in self-defense that day? No, sir. Did Austin want to fight that day? No, sir. There was on cross, it came out that a lot of people were standing up and there was a lot of commotion going on. The witness testified that Austin grabbed Karmelo, which knocked his body back, but then said as soon as Austin touched Karmelo, he stabbed him. And again, that is probably the most egregious description we've seen of the physical contact between Mr. Metcalf and Mr. Anthony before the fatal attack. On day 3 which would be the last day of the prosecutor's case. Another 17-year-old Memorial High School student testified. The question was Austin responding to being provoked? The answer was yes. He put his hand on his shoulder. And then he also stated that no one thought a fight would break out. So you see a lot of kids testifying, we didn't think a fight would break out. You see a couple kids testifying that a fight would break out. Again, you're dealing with a bunch of witnesses trying to speculate what's going on, talking about their emotional experience of it. You got a bunch of young people. You can imagine how horrific this was, how graphic this would have been. So the testimony that has a little bit of inconsistency in it, but not what we're typically not used to seeing in a criminal case. We oftentimes will see little inconsistencies. And again, it's just how the human brain recollects events. Another 16-year-old student testified and said he tried to provoke us, he was trying to provoke us. He even had stated, touch me and see what happens. This is referring to Karmelo Anthony. The witness told the jury that Karmelo instigated the altercation and that, like the previous witness, thought Karmelo was bluffing when he put his hand inside the backpack because it's a high school track meet. You're not supposed to bring anything there. He was asked, was this self-defense or did Karmelo commit murder? Witness responded, he committed murder. I will tell you that those questions, I don't know how the Texas rules of evidence work. Maybe they're a little bit different than the normal rules of evidence. That is actually asking a witness to state a legal conclusion. I don't know if the question was objected to. I probably wouldn't let a witness answer that question. It's asking for a legal conclusion. There is evidence rules on that. But hey, I ain't the judge. Another 16-year-old student testified that Karmelo said when asked to leave, F you all, I'm not going to leave. You're all a bunch of, it's medited, I'm going to guess it's pussies. You're all not going to do anything. And that many people just thought it was tough talk, but Mr. Metcalf got up and asked him to leave. He wouldn't leave. He put his hands on his shoulder, and then the fatal attack occurred. Now, there was a former Memorial High School student, and this is interesting because this is one of the only witnesses that actually knew both the victim and the defendant here. He's familiar with both of them. He said he wasn't paying attention when Austin and Karmelo began interacting because he was talking to other track athletes. That Austin did say to him, who are you? You need to get out of our tent. According to the witness, Karmelo replied, you got to move me. You got to move me, and called Austin a bitch or whatever. The witness explained that he did not remember any other bad words were used, but that he remembers Austin also cursed. So you got a couple of guys talking tough to each other, probably calling out, using all sorts of profanity and things like that. So that was it. Now, let's take a look here. Okay, and again, this witness was asked if this case was about race or self-defense. The witness replied no to both. Again, probably asking to state a legal conclusion, but this witness testified that Austin did not want to testify or did not want to fight, had made that clear. And when asked whose fault was the stabbing, this witness particularly said, I don't know. Did Karmelo have any reason at all to stab Austin? No, sir. So that's where we were there. Now, the next witness is a 16-year-old witness. Described Karmelo as stubborn. The witness testified that Karmelo challenged Austin to a fist fight, and Austin replied, no, I'm not going to fight you at a track meet. He also recalled Austin say, he stabbed me, he stabbed me, he stabbed me after the incident. And then the witness described a hole in Mr. Metcalf's chest, which obviously was very graphic. All right. Then the last witness that we're going to talk about, there was a couple other teen witnesses, and this is always the way you want to end the case if you're the prosecutor, is the medical examiner. Because you can imagine what sorts of things a medical examiner can testify to, the nature of the death, the nature of the injuries, and all the photos come in. So the photos, both pre-autopsy and post-autopsy. One of the things when you have a chest wound that medical examiners, coroners in some jurisdictions will look for is the depth of the wound. Did the person die because of bleeding out, or all stab victims die because of bleeding out, or was the puncture such that it actually hit a vital organ? There was a hole in this kid's heart. So this knife got plunged to such a depth that it actually cut into Mr. Metcalf's heart. And again, I don't want to get too graphic here, but when you start reading about what happened there and the nature of the injuries, there was probably, unfortunately, no saving Mr. Metcalf due to the nature of the injuries. The last bits of testimony and exhibits that the jury heard before the state rested its case were the autopsy photos. I understand the Metcalf family did depart the courtroom for that, probably a good idea. I don't know how many of you have ever had to deal with medical examiner autopsy photos. They are horrifically graphic. They are horrifically graphic. You're basically cutting people up and digging into them and figuring out what's going on. Oftentimes, them just lying in the morgue can be very graphic too, as well. So these would have been very powerful images that were admitted, and that was where the state rested. That was Saturday. They didn't even know they did cases on Saturday down in Texas. So again, to the judge, John Roach, you are definitely stepping on the. Then we get to some defense witnesses here, and this is where things just. I was kind of really digging in, like, okay, what's the theory going to be here? What's the going to be? And you can usually sometimes figure out what the theory of the defense is going to be just through the themes of cross examination. Okay. Now, here's the thing with the kids, and a lot of people were commenting like, well, the defense wasn't really going after these kids. Okay, there's two explanations for that. Okay, number one is there may not be a lot to go after. Okay, sometimes a witness doesn't give you a lot to cross-examine about. The other thing is that these are 16, 17, 18-year-old kids. If you're the defense attorney, the big old bad defense attorney, and you get up in court and you just start wailing away at these kids, and the jury doesn't like it. There's only one person they're going to take it out on, and it ain't you because you're not the one that's on trial, but they will take it out on your client. And there's been a modernization and cross-examination over several years that I was fortunate enough to be taught almost 20 years ago now. But I still spend enough time in court to see a lot of attorneys doing it the old-fashioned way. Isn't it true that you would agree you're a lying sack of shit, whatever it is, the stuff you see on TV, that is not really the best way to cross-examine, but I could do a whole nother video on that. But I just could not see what was the theme coming out. Are they going to try to say that, this was all about race and that the N-word got thrown out? Is they going to say that there were 4 or 5 people threatening them and that now instead of being a one-on-one attack, you have a 5-on-1 attack, which could theoretically increase the likelihood of being subjected to imminent threats of death or serious bodily injury or stuff like that? What would actually be the quantum of proof, the theory that would suggest that Mr. Anthony was facing a threat which was so dangerous, so deadly, so potentially lethal that the use of lethal force would be justified? And I just could not see that coming out, not only on cross, but then in the direct testimony on their witnesses. The first witness they called was Adam Linwood. So this is the first defense witness, coach at Centennial High School. He testified about the track culture. He testified contrary to what other people said, that going to other people's tents, sitting under other people's tents were not that big of a deal. Okay. However, on cross, he testified that actually Karmelo Anthony should have never been up in the grandstands. He should have been down on the track getting ready for his first event. So he has no idea what he was even doing up in the bleachers. Now, there was inclement weather that day. It was kind of on again, off again, rainy day. And so there may have been some weather delays and things like that. So put whatever stock into it you want. When asked what happened that day, shouldn't have happened. That should have never happened, right? The witness said, correct. Okay. Then the defense called an 18-year-old Centennial High School student. Now, this would have been on Saturday. And all he did was kind of paint a picture that the track culture is pretty laid back and being under another person's tent's not that big of a deal. Okay, let's assume that's the case. And let's say that what Austin Metcalf did by telling him to leave the tent was actually mildly inappropriate. It's not illegal. It's not certainly an unlawful use of force. You're telling the person, hey, go somewhere else. The person chooses not to leave, and now a confrontation occurs. The problem is that no evidence of this confrontation. Do I hear anybody describing anything that would have placed Mr. Anthony in imminent threat of death or serious bodily injury, or describe any one of those very serious felony crimes that can be committed upon your person, murder, rape, robbery, kidnapping, things like that, where, yeah, if you're encountered with an imminent threat of that, yeah, you are in fact in imminent threat of death or serious bodily injury. It's about any state in that situation, not just Texas. It's about any state. You could lawfully use lethal force in that situation. On cross-examination, 18-year-old Centennial High School student who was actually called by the defense. So now he or she is being cross-examined by the prosecuting attorney. You seem laid back. If someone asked you to leave, would you? And the witness said yes. You ever carry a knife to a track meet? No. And then, and this is on cross, but this is a defense witness. Who was in the wrong that morning? Answer, I think Karmelo was in the wrong. Question, Karmelo provoked this, didn't he? Answer, yes, sir. Now, that may have taken some air out of the sails of the defense team at that point, because here is one of their witnesses that they put on, and in a very few questions, not very hard hitting questions either. And I appreciate the witness's honesty. That's what we're there to do, is tell the truth. Basically supported the prosecution's theory. That is a big, big blow to the defense at that point. Okay. The next witness was Frisco police officer Bo Riley. They offered to him to prove that blades that aren't, it is not illegal to possess a knife as long as the blade is under 5.5 inches. Okay, that's cool. I believe that. You know where it is illegal to possess a knife, no matter what the length of the blade is? It's on school grounds. And that also was introduced on Officer Bo Riley. So that's where we are. Now, I'm going to check real quick here as I look over here. I'm going to do a refresh on this page because I was expected and I was actually going to. Okay, here we go. 22 minutes ago, folks. 22 minutes ago, court resumes after a 2-hour delay and the defense has rested. Which means, and here, this is, and just so you guys know, I'm following NBC DFW Channel 5. It's an NBC affiliate down there in the Dallas-Fort Worth area. Why? Just because they seem to be, they actually have reporters in the courtroom. And this is the problem with this case. It's not like the OJ case where we all got to watch that happen in real time and then we could all armchair quarterback it from here. I'm trying to armchair quarterback a case in which I'm having to rely on second or third hand accounts of what happened in court. And candidly, even if you read court transcripts, it doesn't give you the full context of what happens in a courtroom. What was the voice inflection? How sure were they in the answer? What was the body language like? There's a lot of things that can be picked up when you're actually watching them live. So, according to NBC DFW, Channel 5, Dallas-Fort Worth, day 4 of the murder trial for Karmelo Anthony, a Frisco teenager who admitted to stabbing a student during a confrontation, continues shortly before 2 p.m. The state rested its case. Oh, man. No, here we go. Let me get the right thing. After a lengthy delay, the defense has rested its case in the first-degree murder trial of Karmelo Anthony. Both the prosecution and the defense have finished presenting their cases, and the jury has heard all of the evidence that will be presented in court. Closing arguments will take place on Tuesday morning, tomorrow morning. The jury will deliberate all day on Tuesday and will be sequestered for the duration of deliberation. The jury will stay at a hotel, blah, blah. That's proper sequestration. Of course, the jury was instructed not to talk about this case. Yeah, good luck with that one. So, listen, I'm going to try to armchair quarterback this thing as best I can, basically relying on second and third hand accounts of what's occurred in the courtroom. But it would appear that the prosecution put together a coherent theory of the case. And what I mean by a coherent theory of the case is that much of the testimony fits together like pieces of a puzzle. That's actually how you want to do things as a prosecutor. You want everything to fit. Were there minor discrepancies in testimony? Yeah, about, minute details. The big picture stuff, however, that came out of every single witness that witnessed the incident, because what you got here is essentially witnesses who saw it happen and then witnesses who saw the aftermath. And I don't think there's any debating what the aftermath is. The medical examiner wasn't even really subject to any type of cross-examination. Mr. Metcalf died from a severe chest wound that actually punctured his heart. Just no doubt about that. Okay. So we saw a lot of these young witnesses who told a very similar story. And the story is that Mr. Metcalf may have placed his hands on Mr. Anthony first. It was done so as kind of a light shove, is how most witnesses described it. A couple of them described it more violent than that. There is no other level of violence that has been testified by anybody in this trial. Not a surrounding of Mr. Anthony by 4 or 5 people, not a bunch of threats. We're going to kick your ass. We're going to beat the shit out of you, whatever, like things like that. If you have a situation where you're about to have hand-to-hand combat, but it's a 5-on-1 type situation, yeah, I don't care how tough you are, there is a high probability you're going to be placed in imminent threat of death or serious bodily injury, especially if you get taken to the ground and they start piling on at that point. So that might have been a theory that they were trying to explore. I don't know why the defense investigators wouldn't had gotten there first. Obviously, all of these witnesses presumably were interviewed by defense investigators as well. So what's going to happen now? And I'll be honest with you, that defense, gee, I just what was actually introduced in the course of the defense's case in chief? That the knife itself was not illegal? Okay. That the track culture may be a little bit more laid back than some make it out to be? Okay. That's literally about all that was deduced out of the defense's theory. And so again, I'm not trying to handicap this. I'm just playing armchair quarterback here for a second. It would appear that the prosecutor had a theory of the case, that they pursued that theory of the case, and that almost all of the witnesses supported that. Actually, I would say all of the witnesses supported that theory of the case, many to the nth degree and some to a considerable fashion. I am still trying to figure out what the defense on this case is. I, you know, there's a couple of different stumbling blocks that the Anthony legal team is going to deal with on this case. The first one is one of proportionality. We've already talked about that. In general, you can only use lethal force, and this is not unique to Texas, it's every state's like this, unless you yourself or somebody in your presence is in imminent threat of death or serious bodily injury. So, had the evidence been that Mr. Metcalf had pulled the knife first and threatened to stab Mr. Anthony, yeah, now Mr. Anthony can make a plausible claim that, he was placed in imminent threat of death or serious bodily injury. Had there been some kind of testimony about 5 or 6 guys surrounding him saying they were going to beat him within an inch of his life, then he may have it. So, even if his use of force is, 1, considered to be legally necessary, and 2, considered to be legally reasonable, the where it's likely to fall apart for Mr. Anthony's defense team is on proportionality. Okay, you don't get to take a knife to a fist fight. Don't get to take a gun to a shoving match. Okay, and so even if the jury were to find that Carmelo Anthony had the ability to use some force in defense, they're going to have to find that the force he used here, plunging a knife into the victim's chest, was proportional to the force that he was actually facing. That is a tough, tough burden to overcome. Okay, so that's the first problem. The bigger problem may actually be this, which is that Carmelo Anthony may be precluded from ever being able to truly raise self defense in general. In Texas, there is a law that's called provocation. Most states call it the first aggressor standard. I could explain the law in all kinds of legal terms, and you guys' eyes would just glaze over and go, "Oh God, it's another lawyer talking like a lawyer." All right, let me explain it to you this way: you can't pick the fight and later claim acted in self-defense. It's really that simple. In Washington State, where I practice, we actually have a jury instruction that says if you are the first aggressor, that's what it's called in most states. If you're the first aggressor, no matter how belligerent the response is from the other side, you've precluded yourself from actually raising any type of self defense at all. I'm not talking about use of lethal force, I'm talking about the use of any force. And there's going to be arguments from the prosecutor. I flat guarantee you, I would be making these arguments as well. That when Mr. Metcalf went under the tent and was told to leave and he refused to do so, that was an act of aggression. When he was told multiple times to leave and refused to do so, that was more aggression. When he said something to the effect of, "Y'all going to have to move me," and reached into his bag and things like that, that also was an act of aggression. If the jury finds that Carmelo Anthony was the person who provoked this entire incident, they will be instructed that they can disregard the self-defense instructions altogether. And that is the problem with first aggressor. Now, a lot of people always go, "Well, how often does the first aggressor come up?" Let me tell you how often it comes up. I'll give you 2 cases that were both tried basically on the first aggressor standard. Kyle Rittenhouse. The prosecutor's theory, out there in Kenosha is that when Mr. Rittenhouse went onto the streets that night, armed with a firearm, which he was lawfully allowed to be in possession of, that was the act of first aggression, and that anyone who then subsequently attacked him had the lawful right to do it because he was the initial aggressor, and therefore he could have never used self defense. That was actually the theory of the prosecution in that case. Now, the jury very correctly said, no, no, actually, Mr. Rittenhouse had as much right to be down there that night as everybody else, including the people who were smashing and burning things. And when Mr. Gruskowitz and the other individual attacked him, trying to bash his head in with a skateboard, Mr. Rittenhouse was placed in imminent threat of death or serious bodily injury, and under Wisconsin law, allowed to use lethal force, which he did. And the jury got that verdict right. Some of you also may remember a case, I think it took place in Georgia. It was a horrific case of Ahmaud Arbery. Ahmaud Arbery was a young African American male who was apparently just out for a jog through a residential neighborhood. Some neighbors didn't like the fact that a black kid was running through their neighborhood, figured he was up to no good. And so they piled into a pickup truck, one with a shotgun, one with a camera, third one driving, and they followed this kid all around the neighborhood, basically chasing him down. And again, this is all captured on video. At some point, Mr. Arbery realizes I can't run away from these guys. He stops. The guy gets out of the truck with the shotgun, starts walking up to him. Mr. Arbery thinks that, oh boy, this is it. And he tries to wrestle the shotgun away from the gentleman. The gentleman gets free and literally shoots the kid point blank range right in the chest with a 12 gauge. All captured on video. The McMichaels, who are now serving life sentences on it, so we know how that one went, claimed that when Mr. Arbery decided to turn on him and come after the gentleman with the shotgun, that was the act of first aggression. The jury, once again, got that verdict right, said, no, actually, when you good old boys decided to pile into that pickup truck and go chasing this kid around the neighborhood for no reason other than the color of his skin, that was the act of first aggression. And the jury got both of those right. So first aggressor standards, provocation, as it's called in Texas, is a big deal. There is currently a case right now before the Texas State Supreme Court where the state of Texas, at least a prosecutor's office in the state of Texas, is trying to really water down provocation. And that could have significant impacts because remember, if we have a much more expanded definition of what provocation is, that is fewer and fewer people who could actually claim self-defense. So it's a big deal. So for those of you who are just tuning in right now, thank you very much. We'll go back through things real quick. We are Washington Gun Law. If you've never watched our channel before, we predominantly talk about Second Amendment litigation and legislation. We do talk about self-defense cases. I'm a criminal defense attorney, have been a criminal defense attorney since 1998. Prior to that, I spent 3 years working for a gentleman named Norm Mailing, an absolutely fantastic prosecuting attorney here in King County, Washington. So I have tried cases from both tables in the courtroom. I spent better part of 25 years of my life in court. I don't have to do it as much anymore. Can't say that I miss it, but it was an exciting time in my life. So I do understand a lot about trying cases and the dynamics of jury trials and things such as that. The jury will be sequestered tonight, which means they will actually be put up at a hotel and their TVs will be restricted from them. Actually, a lot of people don't realize that. They'll unplug the TVs when you're in sequestration because you can imagine if you turn on the local news, how much is going to be on there about this case. I mean, this case is getting a lot of national attention. You can only imagine how much attention it's garnering down there in the state of Texas. For those of you just tuning in, the defense started its case on Saturday afternoon, late in the afternoon. Judge had them do trial on Saturday. We get to Monday today, and we get to the lunch hour, and the defense has rested. And I'm going to be honest, and again, I am not being critical of the defense attorney because, like I said earlier, sometimes you can't make chicken salad out of chicken shit. But the reality of the situation is the defense is rested. I don't know what their theory is going to be on closing. I don't know if them and the prosecutor are maybe going to talk this afternoon and over the evening about a potential plea deal. I think that the prosecutor, if they were going to offer a plea deal, it's a plea discharge, and then we're just going to negotiate how much time are we talking? Anywhere from 5 to 99 years. Interested for those of you who are tuning in right now, if you were the judge and if Mr. Anthony were to be found guilty, what do you believe is an appropriate sentence? I want you to consider that this is an 18-year-old kid, okay? I'm not condoning his activity at all. I'm not excusing his activity. If he's found guilty, it is a murder. I think based upon the evidence that has been introduced at trial so far, the Anthony defense team has an uphill battle. but I've seen crazier things happen. So have you. But we'll see. Okay. For those of you who have interested about some of the other things they've said about this case, there was a lot of criticism about the jury, the racial makeup of the jury. And some people suggested that there'd been some kind of racial gerrymandering essentially going on with the jury. Linked up in the description box below is the first of two videos we have done on this case. And it really talks just about how voir dire, jury selection, jury elimination is what it really is, how that actually works in court. And despite the fact of all of these sudden constitutional experts that we find on social media, you don't get to just strike jurors because you don't like the color of their skin. There's actually a Supreme Court case directly on point. It's called Batson v. Kentucky. It's from 1986. The other side can raise Batson challenge. I'll walk you all through it. So I recognize that there are some who think that race is a big factor here. I'm not going to get into those discussions at all because at the end of the day, Lady Justice is blind, and we really, really want to judge cases based upon an agreeable set of facts that are applied to an agreeable rule of law. That's what it's all about. I will point out that if the races were reversed here, that if a young white male had done this to a young black male, I do think the media might be portraying this a little bit differently, but I'm speculating. Okay. Let's go back through once again. I just want you guys to understand, what is the jury going to be instructed? Okay. A person is justified in using deadly force against another if the actor would be justified in using force against the other under section 9.31. And what I need you to understand is if a jury finds that Karmelo Anthony was not even in a position where he was encountered with any type of unlawful force, so he doesn't get to use any force himself, then obviously the use of any force would be disproportional. The use of lethal force would be grossly disproportional, and Mr. Anthony would find himself in a lot of trouble. But we can use deadly force when and to the degree the actor reasonably believes deadly force is immediately necessary to A, protect the actor against the other's use or attempted use of unlawful deadly force. So, not unique to Texas. No matter where you guys are, and if you want to let us know in the description box below where you're checking in from, love to hear from you. And we're going to go through and I'll take a look at some comments here in a section. We'll maybe answer a few questions for you as well. But no matter what state you're in, if you are an imminent threat of death or serious bodily injury, some crazed madman's coming at you with a hatchet, yes, you are an imminent threat of death or serious bodily injury. You have the right to use lethal force. If you have certain types of crimes being committed against you, and Texas law is no different right here, to prevent the imminent commission of an aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. All of those crimes do what if you are the victim? That's right. They place you in imminent threat of death or serious bodily injury. So it's really just a restatement of the first thing. So in general, you cannot use lethal force, even if you're justified in using force, but you can't use lethal force unless you or the person you are defending is in imminent threat of death or serious bodily injury. So there is a proportionality argument there. Now, the other thing I want you to be aware of, there is an exception in 9.31 and 9.32. So 931 in Texas is use of force. 932 is use of lethal force. But both of them say that so long as the person did not provoke the person against whom the force was used, they have the right to use legal force. But there is a lot of testimony out here. There are even the words that came out of at least one witness, unsolicited, where he said, I felt that I felt that Karmelo provoked this entire thing. If, in fact, a jury finds beyond a reasonable doubt, and that's a lofty burden, but it's beyond a reasonable doubt. Let's get that straight here. If they find that Mr. Anthony was the provocateur, if you were, the one who provoked this confrontation, they could just disregard all the jury instructions as it relates to self-defense at that point. So that is one of the many hurdles to get over. Now, taking a look at the other law, a person who has a right to be present at a location where deadly force is used, who has not provoked the person against whom deadly force is used, and who is not engaged in criminal activity at the time deadly force is used, is not required to retreat before using deadly force as described in this section. And there are a lot of Anthony supporters out there that themselves have suddenly become constitutional experts and legal experts. And they're all saying, Well, this stands under stand your ground law. Stand your ground law. Let's clear that right now. Florida, or excuse me, Texas has a very robust stand your ground law. Many states do. My state, Washington, not known to be a particularly conservative state, we have a very robust no duty to retreat law as well. What stand your ground laws allow you to do is they say that a jury will not consider whether or not you could have fled the scene. And it will tell you that if you are lawfully in that location and not engaged in any criminal activity, you are under no duty to retreat. That's what it tells you. It does not give you carte blanche to use whatever level of force you want under stand your ground laws. Stand your ground laws will never dictate how much force you get to use. Stand your ground laws will determine whether or not you actually have to attempt to retreat. There are some states, Hawaii and Wisconsin come to mind, where in certain locations you are under a duty to retreat if reasonable and possible. And then there are other places where you're under no duty to retreat, like if the crime is occurring inside your house. So, for any of the Anthony supporters out there who want to say this has all to do with the stand your ground law, the stand your ground law would only say that Mr. Anthony was under no duty to retreat. It would not give him a blank check to use whatever force what he felt he wanted to use at that point. Again, the force we use in defense of ourselves has to be proportional to the force we are trying to repel. You don't get to bring a gun to a fist fight. It's kind of how we explain it here. So there is a proportionality problem for Mr. Anthony, and there is also a provocateur or provocation hurdle here as well. So this is a very difficult case for the defense team, and we have found now that the defense has decided to rest their case. And I think they called about 4 or 5 witnesses, and I would love to say there was that aha moment where we're like, aha, there it is. There's the theory case. Oh my God, there's the smoking gun. That's what they're going to hang their hat on. And I just never heard any of that testimony. There are some people who speculated that they were gonna try to get race more involved in this, that maybe, the N word had been thrown out by somebody. Now, how that would justify the use of lethal force, don't know how it would. But again, that word was never even so much as inquired about during the course of trial. So there's 0 evidence that there were any type of racial slurs or racial innuendos or anything like that exchanged between the defendant and the victim here. So the theory goes out the window. The testimony was very, very clear that this was not a 4-on-1, 5-on-1, bunch of guys surrounding Karmelo saying, we're going to beat the living hell out of you. We're going to beat you to death. Any of that kind of stuff where he could have at least put on a plausible argument that, hey, at 5-on-1 at this point, I figured I'm in deep trouble. I got to do something here. Still would have been a long stretch, but at least that would have been a plausible theory. So we don't have either of those. And again, I don't know whether or not I'd have to actually see the witness list. Did the defense actually list more witnesses on it? Here's what I would love to know. Let's say the defense had 14 witnesses on their witness list, and they got through about 5 or 6 of them, and then they were just like, we're done. That might show you that they realize the ship is taking on water too at a rather rapid rate. And the desire to stop this case now and perhaps work with the prosecution over a potential plea deal could be in works. Or we could just end up back in closing arguments tomorrow morning. I am fascinated to see what the defense theory of the case is going to be. And here's the thing. When you get up and you give an opening argument, you can get up and talk about what you think the evidence is going to show. And you can get a little creative with opening arguments. You really can. But once you get to closing arguments, closing summations, whatever they call them in that jurisdiction, well, then you're kind of restricted to 2 things. You only get to talk about 2 things, okay? The evidence that was introduced at trial, not what you were hoping were going to come in, but the actual stuff that is on the record in the trial, and the jury instructions. Now, it's really the only 2 things you get to talk about. Now, you get to talk about your theory of the case, and you get to inflect the motion and all that kind of stuff, and very good trial lawyers will do that. But at the end of the day, that's it. So any kind of theories that they maybe promised in the opening, and I would want to go back and read the opening trial transcripts too, because one of the biggest mistakes that young defense attorneys make, and I see them make this all the time. I made it myself too. I was a young defense attorney at one point. I got my ass handed to me several times. Okay. Is if you get up in opening and you start making all sorts of promises It's going to show this. Evidence is going to show that. We're going to prove this. That cop over there is a liar. That witness over there was high and drunk at the time. You start making all these promises and then you don't deliver on any of them. Well, the jury's going to remember that. Now, there is a burden of proof in this case, and the burden of proof is absolutely positively beyond a reasonable doubt, and it lies absolutely positively with the prosecution. However, if the Anthony defense team has raised self-defense, that is an affirmative defense, different than a general defense. So a general defense is what we'd sometimes call the SODI defense, SODI, which is some other dude did it. Hey, I don't know who stabbed that guy. It just wasn't my guy. Okay, that's a general defense. The burden of proof lies 100% with the prosecution on that case to prove the case beyond a reasonable doubt. O.J. Simpson is a case that comes to mind on that. Okay. However, if the defense raised an affirmative defense, and affirmative defenses are very different than general defenses. Affirmative defense is where you acknowledge the act took place, but then claim you have a legal justification for it. Self-defense is one of those. Duress, necessity, there's other types of self-defense, other types of affirmative defenses out there. Okay, so here's the deal. If you're the defense and you are claiming self-defense, you do have a burden of proof. You have to prove by preponderance of evidence that self-defense was legally justified. Only by preponderance, slightly more likely than not. Okay. And candidly, having tried many of these cases, most judges will give the jury instructions if you kind of put some quantum of proof on the record. Why? Because the easiest way for a judge to get flipped on appeal is to have screwed up the jury instructions. Okay. You screw up the jury instructions, there's no way you're going to determine that's harmless error, and you're going to have a do-over. And you don't want to have a do-over on any trial. I've had to retry this a couple times, and it's not fun to have to try them the first time. It's really shitty to have to try them the second time. But if then the defense proves, at least to the judge's belief by preponderance of evidence, that self-defense is a plausible theory here, then the burden shifts to the prosecution to disprove self-defense beyond a reasonable doubt. However, if a jury or a judge believes that, hey, the defense claims self-defense, but then they never really put on any evidence to back that up, well, this case could go to the jury without self-defense instructions. Is that likely to happen? Again, if you're the judge and you're trying to avoid a do-over, you want to probably err on the side of caution when it comes to the jury instructions. I don't know anything about this judge other than this dude runs a really, really efficient courtroom, because we're already done. For those of you who are just tuning in right now, I appreciate all of you who tuned in so far. Listen, just real quick, we're Washington gun law. We normally talk about Second Amendment litigation, Second Amendment legislation. We do talk about issues related to self-defense. One of the things we try here at Washington Gun Law is different than other content creators. We try to give it to you right down the middle. We just want to give you all the facts. We'll give you the law, the black letter law. We'll tell you what the witnesses said. Our opinion does not matter that much, so we're going to try to keep that out of it. But we are going to we're not going to tell you guys how to think, but we are going to give you all the stuff to think about. I was licensed. I began to practice law in Washington State in 1998. Spent a few years with King County Prosecuting Attorney's Office. Tried a lot of cases as a prosecuting attorney. Probably tried a couple hundred as a prosecuting attorney. Just about anything you could think of. Went into private defense work in the year 2000. Tried a ton of cases as a private defense attorney. Have been more of a full-time content creator the last couple of years in my later 50s, so it's a little bit more enjoyable. And candidly, you never know what you're going to get when you got 12 people in the box that weren't smart enough to get out of jury duty. Okay, you just never know what you're going to get. There are trial lawyers. You will meet trial lawyers who they'll brag to you all the time about cases they won that they had no business winning, and that's true. We all have stories like that. I could tell you a bunch. The ones that are honest, like myself, will also tell you that I got a handful of stories about losing cases that I had no business losing too. You just never know what a jury's going to do. That being said, if I'm armchair quarterbacking, well, I don't even want to say, because I don't want to second guess the work of the lawyers here. It would be really improper for me to be doing that simply because I don't understand all the inner workings. If I'm going to give you a post-game review of the evidence that has come in, our review is this. We believe that the prosecution has put on a theory of the case that was well supported by the witnesses. that whatever little inconsistencies defense was able to develop in the 21 witnesses called by the state, 21 witnesses in 3 days, amazing, were little inconsistencies over minute details. When it comes to the big picture stuff, who was the initial aggressor? Who did what? Who said what? When did it happen in relation to this? Literally, all of these very young witnesses, 17, 16, 18 years old, and you imagine the trauma that has they've been through as well, all told a relatively consistent story. Perhaps the biggest debacle for the defense, if I were to say so, is that one of the defense witnesses did actually testify on cross. Now, this is a witness that's supposed to be testifying for the defense, but actually testified on cross that he believed who was in the wrong that morning. I think Carmelo was in the wrong. Carmelo provoked this, didn't he? Yes, sir. Devastating answers to come out of a defense witness. I'd like to tell you a story about having a defense witness that absolutely blew up in my face. I fortunately have been able to avoid that, probably because we ran them through so much sample testimony ahead of time that you can kind of tell whether or not they can hold the storm. Sometimes witnesses don't. Sometimes, listen. Here's the deal: when you raise that right hand and you sit down in that chair to start testifying, you got to tell the truth. That's the rule. If you don't, that's a crime. And so sometimes you'll come across witnesses where their truthful testimony will not help you. And what is your obligation at that point is to take them off your witness list. Now, if the prosecution gets their hands on them, they get their hands on them, and you're going to have to deal with it. Um, and I see this, especially with young attorneys, they'll put witnesses on the buddy that was riding in the car with them, the buddy that was sitting at the bar when this happens, and they want to get part of the story out of that witness. And they do get part of the story, but then they also leave out big chunks of the story because, well, that's not helpful to the theory. A prosecutor who's even been doing it for 6 months can usually figure that out and just go, oh, well, you don't want to ask about this or this or this. Here's where I'm going. And they'll go there. So I don't know what happened with this witness. It did not work out well for the defense. I will say again, handicapping this case post trial now. I don't the case didn't go well for the defense in general, and I don't think it has anything to do with the skill set of defense team. I think they got very, very talented lawyers, but sometimes you have very, very little to work with. So, for all of you who are tuning in right now, let's put some comments down in the comment section. We're going to stay online for a few more minutes. For those of you who just jumped in now, the Karmelo Anthony case has recessed for the day, and the defense has already rested. The prosecutor could have called witnesses on rebuttal. Okay, so just so you guys understand how a trial works, prosecution has the burden of proof. They put their case on first. The defense then can put their case on if they so desire. Sometimes defense puts on no case whatsoever. Many of you may recall the Randy Weaver case out of Ruby Ridge from a number of years ago, the ATF shootout there in northern Idaho. Jerry Spence, brilliant lawyer, was the attorney on that case. There were 34 government witnesses, 0 defense witnesses. He cross-examined every one of them. He blew them apart. Randy Weaver got acquitted on like 17 felonies. So you can try these cases without putting witnesses on. But since the defense did put witnesses on, the prosecution now, if they wanted to, could put on a rebuttal case. They could put witnesses back on. The rebuttal can only be to rebut what came out through the defense case. You don't get to start adding new theories to the case on rebuttal. You don't get to start piling on and having a bunch of other witnesses come in and say ditto, yeah, what that guy said. There's an evidence rule out there called Evidence Rule 403. A lot of people think it's all about unfairly prejudicial evidence. That's what it's predominantly about. But cumulative evidence and things like that can also be excluded under Evidence Rule 403. The prosecution, as the papers are reporting, and this is make sure I got the news source, and we'll link it up down below in the description box when we're done with the live feed here. This is NBC DFW, Channel 5 in Dallas, Fort Worth, has said the defense has rested and that they are moving to closing arguments tomorrow morning, which tells me that the prosecution is not putting on a rebuttal case. What does that mean? Could mean one of two things. Could mean nothing. This is the way this case was tried. It could also mean that the prosecution now is assessing what, if any, damage the defense did to their theory and they have come to the conclusion that the defense has not really knocked any holes into their theory of the case and that a rebuttal witness or witnesses is not even necessary. Um, Again, I can't get into the minds of these prosecutors. All I can do is talk about my experience trying hundreds and hundreds of cases, the verdict, and just knowing how things work in the courtroom. We're going to be back tomorrow, probably post closing arguments. I kind of want to hear what the theories are. And again, if we had a live feed coming out of the courtroom, I'd feel a lot better about this because, well, it's easier to kind of talk about what happened if you can actually see it happen, see the context, see the body language, things like that. So, again, I'm not discrediting any of the reporters. I'm sure the reporters are doing the best they can do to give us objective information as to what came out of the courtroom. Obviously, I also don't expect the reporters to be, well-versed trial attorneys and able to understand all the nuances or what to be looking for in certain situations like that. So we are somewhat limited. And that's the big reason why, well, that and because what we do at Washington Gun Law is I'm not going to tell you guys how to think. You're all going to come to conclusions yourself. I just want to make sure you guys are using good, reliable information to reach the conclusions that you have. So, anyways, all right. With that in mind, let's take a look at some of our comments here. All right. Well, we got a lot of comments. Do we got any questions down here? Oh, that one's not nice. Come on, people. Uh, okay. It's not. We got a question here. It's not capital murder. Here, actually, here, I think we can show them. Oh, look at that. It's not capital murder. When the verdict comes out of third degree, I'm gonna laugh. Okay. I don't believe that this is being charged under a degree of murder. I'd have to go back and take a look at the Texas statutes. In Washington State, for example, we got homicide in the first degree, homicide in the second degree, manslaughter one, manslaughter two. Capital murder is the only thing that is punishable by death in the state of Texas. As you know, the state of Texas is very serious about that. You go to Texas and kill, they will try to kill you back. Um, the If a verdict comes out, it will be on a conviction of murder, and the kid is looking at anywhere between 5 and 99 years. I think there is a possibility that this afternoon, the defense team and the prosecution could be sitting there trying to agree to a plea deal. I will tell you that has probably gone down a little bit because with the defense resting, because if I'm the prosecutor, I'm sitting there going, well, I could get a conviction, but I could go through 3 more days of trial. The defense is rested now. So now my decision is well, I can work out a plea deal or I can just give a closing argument. And they pray. And candidly, if you're preparing your case correctly, you actually start with your closing argument. That's the first thing you prepare. And then you work back from that because what you want to do is this is the theory of the case. This is how I believe I'm going to win the case. So you start with your closing argument and then you work back from there to make sure that you're going to actually have evidence to establish the theory in your closing argument. As you work backwards, if you realize that's not going to work or that's not going to work, well, now you're going to have to change your closing argument because your whole theory is going to change. Shockingly, in the world of courts, everything is still dictated by that pesky little thing called evidence. So, I don't think that we're dealing with a third degree or anything like that. Man, you guys are not real nice here to this kid, so I get that. All right, here we go. Defense rested because they know they're cooked and their star witness lied under oath. It is possible. It is possible. Honestly, if you had a witness that got cooked, the better strategy would be to continue to try the case and put other witnesses on and hope that the jury forgot about the witness that got cooked. If one of your last witnesses gets detonated on the stand right there and that's what you leave the jury with, not the best last impression. So, again, I'm speculating, you're speculating, we don't know. But yeah, obviously, here we go. It's capital murder. Next rung down is murder, 5 to 99 years. Thank you for this. That's 8491C. Thank you for this. Capital can't be charged. He was too young. Okay. Okay. And you're suggesting or predicting a sentence between 30 to 40 years. That may be exactly the case. But thank you for those comments because, again, this is a Washington state lawyer trying to figure out Texas law on the fly, talking more about general trial theories and things such as that. So, listen, we will be back tomorrow afternoon after the closing arguments. We will take another look at this case. We will take a look at where the case sits, what the theory from the prosecution was, which I have a very good idea what their theory is. It's probably the exact theory I would have tried this case under. I'm very interested to see what the defense theory is because how can I say this? They don't have a lot of pegs to hang their hats on here. There's just not a lot of evidence that came out either on cross examination of the state's witnesses or on direct examination of the defense witnesses. There's just not a lot that came out here. And so I don't know where they're going to go with this. And again, if you watch trials, if you pay attention to trials, especially if you've defended people, you'll start picking up on themes and possible defenses. You can see them kind of woven in there. And I just never saw that really in any of things that happen here. So, anyways, that is all of our wrap up for it now. Now, listen, I want you guys to make me a couple of promises. I think that this case has got a lot of charged energy in it, and I completely understand that because a young person had his life taken. And anytime someone loses their life, it's a horrible thing. And a young person's even worse because they have so many good years left in front of them. There's a racial component to this case as well. I know many of you are rolling your eyes. I understand that. I think that race gets injected into far too many things, and the criminal justice system is one of them. However, we're going to see a lot of emotional reaction one way or the other because if this case does go to a jury, they are either going to convict or quit. I don't see a hung jury on this case. And there's going to be an emotional outburst from the side that does not prevail. I want all of you to be careful. I don't want you guys to fan those flames. Okay. And I want you to be really careful if you're in volatile neighborhoods where you may be depoliced. I don't think you have to worry about that in Texas. I'm up here in Seattle. But understand that sometimes when things don't go the right way as the side believes it should, they will react in emotionally unregulated ways. So please be careful about that and do what you can do to spread the information that we and other content creators are providing out there so that people who are still curious about this case or believe that if there is a conviction that that was the wrong verdict, you can educate them. Because at the end of the day, a lot of this just comes down to educating. I get the other side sometimes doesn't want to listen very well. I recognize that. But once again, and just to show you guys here, if you want to look it up for yourselves, so you don't have to take our word for it. Texas Penal Code 9.31 and 9.32 is what we were talking about today. It is all listed right there. You just go Google up Texas Penal Code Section 9, scroll down to 931 and 932. You will see the applicable law. The jury will be instructed to this law. Jury instructions basically are taking this convoluted legalese and breaking it down into simple English so that a jury could understand it. So this is how a jury is going to be instructed. And as we've mentioned, the two big issues for the Anthony defense team is going to be one of proportionality. I haven't heard any evidence at all to suggest this kid was encountered with unlawful force that would have risen to the level of him being able to lawfully use lethal force. And then on top of that, there's a good evidence that suggests he may have been the one that provoked this confrontation. And under Texas's provocation law, he's in big trouble. So that's where we're at right now. Listen, I will check out the comment section later today. I actually got to get ready for another live cast tonight at 5 o'clock. For those of you who are big Second Amendment geeks, we'll be live tonight at 5 p.m. West Coast, 8 p.m. East Coast for Behind Enemy Lines, what I do with Coast This Morrows over at Second Amendment Foundation. Anyone from Virginia online, we got Cam Edwards joining us tonight, and we're going to be talking about everything in Virginia as it relates to your gun laws that a bunch of prosecutors and sheriffs appear to not want to enforce at all. So we're going to talk about what that means to all of you. Listen, for those of you just joined in late, they have rested. The case is recessed for the day. Opening arguments will be tomorrow. That will be June 9th, Tuesday morning, unless we hear this afternoon or tomorrow morning that there's been a plea deal. If there has been a plea deal, we'll probably get back online and let you know what it is. I want to thank all of you for tuning in. I appreciate it. I had over 1,000 of you tuning in live. This is not something we normally do. We don't normally do live armchair quarterbacking of trials. We'll tell you the whole reason we did it is that Mrs. Gun Law, who just loves crime thrillers and things like that, her and I have been geeking out about this case a lot. She's had a lot of questions. My wife's not a lawyer, which probably makes so wonderful as a wife. And she was asking me a lot of questions about what about this? What about that? Why does the jury do this? Why does the judge do that? Blah, 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 blah. And I was able to answer the questions for her because I've been there, done that. And that's when she said, you really need to do kind of live blogs during this trial. So I was hoping to get to do this for a few days. It looks like we might get to do it one more day, and then we'll be talking about a verdict or a potential plea settlement. I want to thank all of you for tuning in, especially for those of you who are regular viewers of Washington Gun Law. Thank you so much for all your support of the channel. If you're new to Washington Gun Law, check us out. like I say, we're always going to give it to you straight. We're not going to try to clickbait you. We're not. If something can be explained in 6 minutes, we'll explain it in 6 minutes and not turn it into a 16-minute video. Check out the channel because as soon as I know when we're likely to go live again tomorrow, I will turn around and post that time. Of course, for those of you who checked out, joined us late, you want to go back to the beginning, it will be available on replay here in about 15 minutes, and you can watch it from the beginning. I want to thank all of you for tuning in. I want all of you to stay safe. Keep your head straight. Keep your head on straight. Let's stay clear in our thinking here. Let's remain objective. Let's let the jury do their job. I think a lot of us have a suspicion on where this case is going to go. So thank you for joining us. Enjoy the rest of your Monday and please stay safe.